Office. I am actually posting this video today because there's a lot of great news immigration wise this week. USCIS and the Department of Homeland Security redesignated several countries for TPS. Well, it's really a temporary designation because there was some litigation regarding the revocation of TPS before. So if you are from Haiti, Sudan, Nicaragua and El Salvador, your actual TPS grant, if you applied for TPS at the last redesignation, which was last year, it was actually automatically extended until that preliminary injunction from the court in California actually gets lifted. So what I want to talk to you about today is a couple of things. I'm going to tell you what TPS means. I'm going to talk to you about what preliminary injunction means and what that means to you if you're from these countries. Again, these countries are Haiti, Sudan, Nicaragua, and El Salvador. So what's TPS? Temporary protected status is just that temporary. Under the regulations and the Immigration Naturalization Act, the Department of Homeland Security can actually designate certain countries that have had civil war, for example, who have had natural disasters that don't allow their nationals in the United States from returning to their countries. Now, Haiti, for example, was designated after the 2010 earthquake that happened that really ravished the country and did not allow people to go back. I actually represent a lot of Haitian clients that came here to the United States after the earthquake and were allowed to stay here. So what happens with TPS? TPS again is temporary, as the name says. The Department of Homeland Security has to redesignate a country for TPS every couple of years for these people to be allowed to actually stay here in the United States without being forced to go back. What happens when you grant a TPS is that the government will not be allowed to actually deport you as long as the TPS designation is current and you apply for TPS designation as the law allows you to do it. You have to do it within a period of time that the government gives you to reapply for designation. Now, earlier last year, the DHS came out with a ruling saying, okay, for all these countries, we're going to de-designate the countries because really there is no effect of the natural disaster anymore, and you can actually go back to Haiti or Sudan or El Salvador or Nicaragua. Under the regulations, these things, the decision of the Attorney General to de-designate someone, or the Department of Homeland designation to be revoked, is not reviewable unless there is some sort of due process or a constitutional challenge to that actual decision. The decision itself has to go through a lot of steps, and one of them is for the DHS to speak to the representatives of these countries and ask them if they can actually absorb all of these people coming back if we kick them out of the United States. I highly doubt that actually happened, at least with Haiti. I don't think they actually got any response from the other countries, but they still de-designated these countries for registration, and the registration was supposed to actually expire, at least for Haiti, in very soon actually within I think on June of this year it would be de-designated. So these people in Ramos v. Nielsen, which is a case that actually applies here, sued the government and saying, hey, the designation decision that was made last year is actually violates constitutional rights, and that's why you have to actually stop the government from enforcing it. And one of the things that the plaintiffs can do in federal court is to actually sue for or ask for a preliminary injunction. And as you know, I'm actually admitted in several federal courts, including the Supreme Court, and we do a lot of that litigation. So they actually sued and said, hey, they shouldn't actually kick us out of the country. because of this problem, because that decision was arbitrary and capricious. One of the things that they actually said in this lawsuit is that the secretary designated these countries because of ethnic origin, and the decision wasn't actually in accordance with the law. Now, for you to actually win under a preliminary injunction, you have to show that the legal standard is you have to show injury and the likelihood of success down the road in your litigation. And the Northern District of California said these people have actually shown enough for us to actually grant this temporary injunction against the government from enforcing this. And the injury here is that these people are going to be deported. So if this injury happens, these people will actually be injured, and that's why we should give the government, or we should slap the government with a temporary injunction saying that you cannot do it. Last week the Department of Homeland Security published a ruling in the Federal Register saying, hey, we're not going to actually de-designate it as long as this litigation is actually in place and a temporary injunction is actually in place. We're not going to take it away from you. And the cool thing about the decision is they said we're going to automatically extend your work permit and your stay, which means that now you're going to save to file on legal fees. You're going to save, the fees to pay for a work permit, which is about $500. So you don't have to pay that. They're going to extend it automatically until that actual injunctive relief is lifted by the court. Now, there are a lot of things here. As I said earlier, I represent a lot of Haitian clients. A lot of my clients come here. Probably they got bad advice before, telling them that you don't have anything other than TPS. A lot of them have adult children who are here, who are 21, who are U.S. citizens, and can actually apply for a green card for them. Some of them actually qualify for asylum because they have some sort of disability, or their kids have some sort of disability. So don't just give up because someone told you can't. I would urge you, if you actually have TPS right now and you're Haitian, and you haven't met and you haven't seen anybody who's an immigration attorney in a long time, I would at least come for a consultation with an immigration lawyer and speak to that person to see if there is anything new that you can do. There have been some changes on the law that allows you to apply for a green card. I wouldn't just give up on it, because honestly, this is temporary injunctive relief that the court can lift at. If they can petition for it, and the government shows that there might be something that the court got wrong, they can actually appeal the decision to a higher court, and that higher court can actually take away the injunctive relief, just like we saw with DACA and DAPA. So if you're from one of these countries, or you have TPS, or you've been paroled into the United States, I would urge you to call an immigration attorney. And as always, you can always call me at 1-888-963-7326, 1-888-96-DREAM to actually set up a consultation or come see me. Give me a call. We're open 24/7. You'll be able to see me very quickly. Thank you very much.